Uh-oh, Sam Bankman-Fried is now Sam Bankman-Filen. Yeah, this was apparently news to Bankman-Fried. He was scheduled to testify in front of Congress on December 13th, and just 24 hours earlier, while playing video games in his Bahamas penthouse, he told interviewers that he would have to attend the hearing by Zoom because he was quite overbooked. He also remarked, "I don't think I will be arrested." And maybe when he said overbooked, he meant about to be booked. Because later that same day, authorities arrested Bankman-Fried, took him into custody, and prepared to extradite him to the United States, where he's been indicted for wire fraud, securities fraud, commodities fraud, money laundering, and illegal campaign contributions. Classic Pisces. And now we know that most of the C-suite at FTX, including Bankman-Fried's confidants, have reached plea agreements with the government and are cooperating with the government against Sam Bankman-Fried. And this helps explain how things moved so quickly. And as we discussed in our last video, it looked like there was going to be a jurisdictional tussle between regulators who would win the right to prosecute Bankman-Fried. Now we know the regulators decided that there was enough criming and torting to go around for everyone, with civil complaints being filed by the Securities Exchange Commission, the SEC, and the Commodities Futures Trading Commission, the CFTC, as well as criminal charges by the Department of Justice. Fortunately for Bankman-Fried, he's used to living with tons of roommates and wearing the same clothes every day. Now, before we get into all of the alleged crimes, and there are a lot of alleged crimes, let's do a quick factual rundown because now we have the benefit of 3 detailed proceedings, 2 civil complaints and 1 criminal DOJ indictment. Now, the SEC and the CFTC filed separate civil complaints, providing additional factual context to what is alleged to have gone on here. As you probably know, Bankman-Fried was the founder of Alameda Research, which he represented as a separate entity from the FTX entities, especially after Caroline Ellison and Sam Trabucco became co-CEOs of Alameda in 2021. However, the SEC and CFTC say that Bankman-Fried did not hand off Alameda Research at all, and that he remained the ultimate decision maker at Alameda. The SEC says that Bankman-Fried directed investment and operational decisions, frequently communicated with Alameda employees, and had full access to Alameda's records and databases. And the CFTC says that Bankman-Fried operated all of these entities as a common enterprise, which is no surprise given the allegations that we've seen in the news where basically they were commingling all of these funds. So in other words, FTX, Alameda, and many of their related businesses were all run by Bankman-Fried and Alameda without any corporate controls or separation that Bankman-Fried promised. The CFTC said that all of this was baked into the cake. Quote, FTX trading executives also created other exceptions to FTX's standard processes that allowed Alameda to have an unfair advantage when transacting on the platform, including quicker execution times and an exemption from the platform's distinctive auto liquidation risk management process. Now, all of this started coming out in November. You can check out my earlier video on how this came to be. In December, just before Bankman-Fried was going to testify in Congress, he was arrested in the Bahamas where he lives. The U.S. Attorney's Office for the Southern District of New York presented evidence to a grand jury. The grand jury indicted him, and then the U.S. Attorney's Office made provisional requests for his arrest with the Bahamas. The U.S. has an extradition treaty with the Bahamas, and that extradition treaty will take a while, but eventually he will be transferred to the custody of the American authorities. That means that Bankman-Fried faces a 3-headed monster because the SEC and the CFTC cases will have broad discovery procedures, which will force Bankman-Fried to turn over documents. He'll have to give a deposition testimony, which could incriminate him in the criminal case, and his lawyers will probably ask the court to stay the civil cases while he defends the criminal case. The judge has the discretion to decide whether to grant that motion, though don't be surprised if Bankman-Fried ends up taking the fifth on a lot of this stuff. Though in the civil proceedings, taking the fifth can be used against you and adverse inferences can be drawn by your assertion of the Fifth Amendment. Though the SEC has more power than the criminal court to immediately freeze actions by the entities that are under the Alameda FTX banner. And the plea agreements from Sam Bankman-Fried's compatriots paint a damning picture. Former Alameda Research CEO Caroline Ellison and FTX co-founder Gary Wang have now pleaded guilty to federal fraud charges and are cooperating with the Justice Department's investigation.
I want to make 2 announcements. First, I'm announcing that the Southern District of New York has filed charges against Caroline Ellison, the former CEO of Alameda Research, and Gary Wang, a co-founder of FTX, in connection with their roles in the frauds that contributed to FTX's collapse. Both Ms. Ellison and Mr. Wang have pled guilty to those charges.
The Justice Department made the announcement on December 22nd, the same day that Bankman-Fried waived extradition to the US. Bankman-Fried is now out of jail and back in his mom's basement as a result. The federal courts set bail at $250 million, and Bankman-Fried was bonded out. Now, a bail bond is usually about 10% of the total bail amount, so we probably had to come up with around $25 million in assets. The court record shows that his parents will need to post equity interest in their home by January 12th, 2023. And this comes just weeks after Bankman-Fried told told George Stephanopoulos that he only had about $100,000 left in his bank account. Now, the bail disposition said that 2 non-parent sureties would also sign bonds for lesser amounts. The terms of the release require Bankman-Fried to surrender his passport, and he'll be confined to detention at his parents' home in Palo Alto, California, where he will have to wear an ankle monitor. Bankman-Fried's parents co-signed the bond, and Bankman-Fried is barred from starting a business or operating new lines of credit more than $1,000 unless approved by the government or the court. The court records show that he'll need to undergo a mental health evaluation and may request to leave the house for exercise. Now, Caroline Ellison's unsigned plea agreement says that she admitted to 7 counts, including committing wire fraud on FTX customers and lenders of Alameda Research, conspiracy to commit commodities fraud and securities fraud, and conspiracy to commit money laundering. Now, the maximum sentence of incarceration on those counts is 110 years, but she's not going to face anything like that, especially because she's cooperating. But Ellison must continue to cooperate or else she could be charged with other crimes. Ellison also agreed to the forfeiture charge, and the government says that it cannot agree not to prosecute her for tax fraud if those charges are appropriate. By pleading guilty, Ellison is not guaranteed a lighter sentence, but typically defendants who cooperate completely do get a lighter sentence. And the plea agreements also require her to make restitution. Ellison was released on bail but cannot leave the country. Wang pleaded guilty to 4 counts of wire fraud and conspiracy to commit wire fraud, commodities fraud, and securities fraud. The maximum sentence for those crimes is about 50 years in prison. Wang also agreed to restitution to his victims and agreed to the forfeiture. Now, the same cooperation terms apply to Wang, but he was also released on bail with a condition that he not leave the country. Both plea agreements included sections that are redacted so as not to tip off Bankman-Fried and other targets about specific information that Ellison and Wang shared with investigators. And in separate actions, the SEC charged Wang and Ellison with securities fraud, and the CFTC also filed fraud charges against Ellison and Wang. The CFTC's amended complaint against Bankman-Fried adds charges against Ellison and Wang for fraud and material representations in connection with the sale of digital asset commodities in interstate commerce. And the CFTC hit Wang for creating the code features in the FTX trading platform that allowed Alameda to have an unlimited credit line on FTX without being detected. And the CFTC complaint offers more details about what happened in November when crypto declined and FTX could not keep up with customer withdrawals. Publicly, Bankman-Fried claimed that there was just a liquidity problem, while privately, quote, Bankman-Fried, Ellison, and other key personnel at FTX and Alameda acknowledged internally that this shortfall was not merely a matter of having sufficient liquid assets on hand to cover customer withdrawals in the short term. Rather, FTX customer assets were irrevocably lost because Alameda had misappropriated them. The CFTC says that Bankman-Fried's infamous tweet threads of November 6th and 7th, the ones where he apologized for being a screw-up and accused Binance of trying to sabotage FTX, were workshopped ahead of time with Ellison, Wang, and other advisors. The CFTC says, quote, several individuals expressed concerns that Bankman-Fried's tweet was inaccurate and or misleading. And on November 9th, after Binance announced that it would acquire FTX in its entirety, Ellison held an all-hands meeting with employees of Alameda Research. During the meeting, she provided detailed information about the years-long fraud. Quote, Ellison stated that starting last year, Alameda was borrowing a bunch of money by open-term loans and used those assets to make very illiquid investments. Ellison further explained that following the widespread decline of digital asset prices, most of Alameda's loans had been recalled, and in order to meet those recalls, Alameda borrowed a bunch of funds from FTX, which in turn led to FTX having a shortfall in user funds. Ellison informed Alameda staff that FTX had always allowed Alameda to borrow customer assets and did not require collateral for those loans. She also explained that Alameda could access user assets without requiring FTX's approval, as the structure allowed Alameda to go negative in coins. In response to an employee question, Ellison also acknowledged that her November 6th tweet to the Binance CEO offering to buy his FTT holdings at $20 per token was kind of a misleading thing to tweet, and expressed remorse. Shortly after this meeting, most of Alameda's staff resigned. So basically, Caroline Ellison sort of admitted to, borrowing a bunch of money from FTX, being allowed to have like a negative balance, and that FTX and Alameda just kept moving stuff around until the bottom dropped out of the market. And then, what do you know? There's nothing left to borrow and the customers couldn't withdraw their money. Classic Pisces. One day later, FTX and 133 related entities filed for bankruptcy.
I declare bankruptcy!
It was all, very cool, very progressive, very edgy until, it wasn't. Ellison and Wang do not contest their liability to the CFTC's claims, and their testimony makes it very hard for Bankman-Fried to claim that he didn't know what he was doing and, aw shucks, he was just a big old mistake. Wang and Ellison also agreed to the entry of consent orders of judgment as to their liability for engaging in massive fraud. The SEC complaint against Wang and Ellison gives us more clues about how they were cooperating against Bankman-Fried. with respect to the fiat@ftx.com account, the SEC said that some of the bank accounts, quote, were not in Alameda's name, but rather in the name of North Dimension Inc., an Alameda subsidiary. North Dimension's website does not disclose any connection to Alameda, but apparently Ellison knew that Bankman-Fried had directed FTX to have customers send funds to North Dimension in an effort to hide the fact that the funds were being sent to an account controlled by Alameda. Apparently, Alameda didn't segregate those customer funds, and the North Dimension account is actually the multi-billion-dollar debt referred to as the fiat@ftx.com account. The fiat@ftx account was then listed as a loan on the quarterly balance sheets, and Ellison allegedly, at Bankman-Fried's direction, combined this liability with loans Alameda had received from third-party lenders to obscure Alameda's intertwined financial relationship with FTX. Now, this information, if true, is fairly damning evidence of the defendant's intent to mislead and conceal information from investors, lenders, and customers. The complaint says in 2022, FTX started trying to separate Alameda's debt in the fiat@ftx.com account from the portion attributable to FTX. And when Alameda's portion was moved to a different account, it triggered a process that added interest to Alameda's debt. Quote, Bankman-Fried directed that the Alameda liability be moved to an account that would not be charged with interest. This account was associated with an individual that had no apparent connection to Alameda. As a result, this change had the effect of further concealing Alameda's liability in FTX's internal systems. And when crypto started crashing in May, causing Alameda's lenders to come calling, Bankman-Fried told Ellison to hide the unlimited line of credit on the balance sheet so that the lenders didn't know about it. And Ellison admitted to making statements that she knew were untrue. For example, in a Bloomberg article from September 2022, Bankman-Fried claimed that Alameda is a wholly separate entity than FTX, and in the same article, Ellison is quoted as stating about Alameda, quote, we're at arm's length, we don't get any different treatment from other market makers. And as for the technical issues, Wang designed the so-called risk engine that Bankman-Fried touted to investors. The SEC complaint notes that Bankman-Fried touted this risk protocol when he testified to Congress. Quote, there's a complete transparency about the positions that are held. There's a robust, consistent risk framework applied. Of course, one of the biggest problems is the risk engine didn't apply to FTX's biggest customer, Alameda Research. Wang knew this because he was the person who created the code exempting Alameda Research from the rules, and that Ellison was aware of and took advantage of this special undisclosed benefit. Of course, this is just scratching the surface. There's additional juicy details about Alameda propping up the price of FTT, FTX using bots to manipulate the entire market, and then the employees and founders issuing giant loans to each other at the company's expense. Now, the SEC complaint alleges that Bankman-Fried violated two parts of the Securities Exchange Act of 1933, breach of Section 17A and 10B. Both of these sections prohibit making false representations to investors as opposed to customers who would be the exchange's users. Now, the crux of the SEC's charges are that Bankman-Fried transferred billions of dollars of FTX money to Alameda Research while misleading FTX's investors about FTX's financial condition and risk management.
At the end of the day, look, there's a question of what happened and why.
Alameda used this money to cover loans and make additional venture investments and personal loans to Bankman-Fried and other FTX investments. Even in November 2022, faced with billions of dollars in customer withdrawal demands that FTX could not fulfill, Bankman-Fried misled investors about a multi-billion-dollar hole. Now, the SEC alleged that Bankman-Fried committed fraud in the offer or sale of securities in violation of Section 17A. The section makes it illegal to mislead investors. Specifically, it says it's unlawful to employ any device, scheme, or artifice to defraud, obtain money or property by using material misstatements or omissions, or to engage in any transaction practice or course of business which operates or would operate as a fraud or deceit upon the purchaser. Now, the SEC typically relies more on Rule 10b-5 for its enforcement actions, but in recent years has stepped up prosecutions under 17A, in part because of the regulation's weaker scienter requirements. Now, scienter is another word for the mental intent, the knowledge of wrongdoing. And when the SEC brings a civil case, as it did here, a violation of Section 17A can be established if the defendant acted negligently. In contrast, a civil violation of Rule 10b-5 requires that the defendant must have acted at least recklessly, which is a higher mental state than just negligence. The SEC says that Bankman-Fried allowed Alameda to have a negative balance on its account without any collateral requirements and gave Alameda unlimited access to credit. No other account had these privileges, and they were accomplished by writing Alameda-specific bypasses in the FTX codebase in August 2019. Alameda's collateral was also allowed to fall below the requisite margin levels without triggering the automatic liquidation of its account. And while Bankman-Fried pulled strings to give Alameda these special privileges, he did not disclose any of them to FTX investors. Though news News reports also suggest that investors did not do proper due diligence in FTX, but perhaps that was partly because Bankman-Fried did not give the investors much information to work with, telling them to look at the terms of service and pointing to a document called FTX's Key Principles for Ensuring Investor Protections on Digital Asset Platforms, in which FTX claimed that it, quote, segregates customer assets from its own assets across our platforms. Now, the SEC says FTX provided this document to potential investors, quote, including a US investor who invested $35 million in FTX's Series B fundraising round in July 2021. But these statements were false, as FTX did not segregate customer assets from its own assets, and as events would later demonstrate, did not maintain liquidity to allow customer withdrawals on demand. Now, FTX did provide audited financials, but those statements don't include information about Alameda's undocumented line of credit from FTX or the other information about its special deals with Alameda. Bankman-Fried told investors that Alameda did not get any special treatment, and that he told his executives to emphasize that FTX and Alameda were two separate entities. The SEC says that all of that was materially misleading, and that seems kind of like a slam dunk case. Now, the SEC also alleges that Bankman-Fried violated Section 10b-5, the more traditional fraud provisions that are used in a situation like this. The SEC alleges that Bankman-Fried used creative accounting and little documentation to hide his personal loans. According to the complaint, quote, between March 2020 and September 2022, Bankman-Fried executed promissory notes for loans from Alameda totaling more than $1.338 billion, including two instances in which Bankman-Fried was both the borrower in his individual capacity and the lender in his capacity as CEO of Alameda. Bankman-Fried used these loans to make political contributions and buy real estate for himself, his parents, and other FTX executives. And besides all of this, the SEC alleges that, quote, the record keeping regarding the purchase and ownership of real estate was poorly organized and documented. Neither the fact of the loans and the purchases nor the poor documentation of significant company liabilities and expenditures was disclosed to investors.
So you do know, and you did know, that FTX deposits were being funneled to Alameda?
So I was vaguely aware that that was how some wires were being sent in the first place.
Now, I'm sensing a theme here. Now, the SEC also cites a September 2022 meeting for US investors in which FTX claimed, quote, outside of BlockFi, we didn't increase our exposure to crypto. That statement was, quote, false and misleading. Bankman-Fried knew that as a result, FTX's exposure to crypto, including its own FTT token, increased substantially as Alameda increased its borrowing backed by FTT as collateral. Now, the SEC lawsuit is a civil enforcement action, which means that it isn't charging Bankman-Fried criminally. That's what the DOJ is doing. But the complaint seeks disgorgement, i.e. paying back of all the ill-gotten gains, civil penalties, a ban on Bankman-Fried acting as an officer or director of a company, and to prohibit him from participating in the issuance, purchase, offer, or sale of any securities in the future. Now that takes us to the CFTC complaint. Now I told you before that the CFTC believed that it had the authority to regulate crypto as a commodity, and its complaint against Bankman-Fried and FTX makes no bones about it. Quote, certain digital assets are commodities, including Bitcoin, Ether, Tether, and others as defined under the Commodity Exchange Act. Thus, the agency filed a complaint naming Bankman-Fried, FTX Trading Limited, and Alameda Research LLC as defendants. Much of the CFTC's complaint reiterates facts let out concurrently in the SEC's complaint, including all the stuff about the special treatment of Alameda Research that it got from FTX and the fact that Alameda Research served as a limitless slush fund for Bankman-Fried and other FTX executives. In fact, the CFTC says that these built-in advantages for Alameda, quote, directly contradicted public statements made by and on behalf of defendants. This allowed Alameda to use FTX assets whenever it needed to pay off its own lenders. The CFTC says that FTX also made a giant no-interest loan to Alameda, which it concealed with the now infamous line item on the balance sheet called fiat at. Quote, during the relevant period, this account held a balance of as much as $8 billion in customer funds. Now, that wasn't the only time that Bankman-Fried used a weird trick your accountant doesn't want you to know about to hide an enormous liability. Quote, at least in part to remediate the risk that Alameda's large liability would be discovered, at Bankman-Fried's discretion, FTX executives reallocated Alameda's approximately $1 billion in liabilities to a customer account on FTX's system that Bankman-Fried would later refer to as our Korean friend's account and or the weird Korean account. This was technically a sub-account of Alameda, but unlike other Alameda sub-accounts on FTX, it was not opened under a @AlamadaResearch.com identifier and was not otherwise readily identifiable as being an Alameda-associated account. This, in plain terms, seems like fraud. Now, the CFTC charged Bankman-Fried with violating Section 6C of the Commodities Exchange Act, which is basically patterned after Rule 10b of the Securities and Exchange Act. The law is a broad sort of catch-all provision that prohibits fraud in all of its forms, and the law prohibits manipulative and deceptive devices and contrivances in connection with any swap or contract, basically anything anything in relation to the sale of a commodity. Now, the newest amendments to the law were added in 2010 by the Dodd-Frank Act, which make it easier for the CFTC to charge fraud because the government no longer has to prove that a defendant specifically intended to create a price trend that was manipulative. Now, the CFTC can charge anyone who uses manipulative or deceptive devices is intentionally reckless in conduct that's intended to create or did create an artificial price. Now, that takes us to the criminal indictment from the Department of Justice. The U.S. Attorney's Office for the Southern District of New York, which handles a lot of financial crimes because New York City is within the Southern District of New York, and they obtained an indictment against Bankman-Fried for conspiracy to commit wire fraud, conspiracy to commit commodities fraud, conspiracy to commit securities fraud, conspiracy to commit money laundering, and conspiracy to defraud the Federal Election Commission and commit campaign finance violations. Now, we kicked off our first video about Bankman-Fried by discussing the possibility of wire fraud, and what do you know? It was wire fraud. Wire fraud specifically involves the use of telecommunications or online communications, including emails, social media, text messages, or even good old-fashioned fax machines. The unsealed indictment says that starting in 2019 and continuing until November of 2022, Bankman-Fried committed wire fraud. Now, this might not have come as a complete shock to Bankman-Fried because according to the Australian website Financial Review, Bankman-Fried and his FTX and Alameda associates had a secret chat group called cryptically Wire Fraud. The group exchanged secret messages on Signal about the potential for US wire fraud charges for their role in the implosion of FTX and Alameda Research. In response to the allegation, Bankman-Fried tweeted, "If this is true, then I wasn't a member of that inner circle. I'm quite sure it's just false. I have never heard of such a group." Though, on the other hand, maybe he just wanted to save the Department of Justice a whole bunch of money in making it super easy to prosecute him and everyone that he worked with. And as I mentioned, the government also criminally charged Bankman-Fried with various species of conspiracy to commit wire fraud, securities fraud, commodities fraud, money laundering, and campaign finance violations. And regarding that last charge, prosecutors said that Bankman-Fried misappropriated tens of millions of dollars of customer funds to make illegal donations to both Democratic and Republican candidates. So the question is, if Bankman-Fried is convicted, how long is he going to jail? Well, the CFTC and the SEC filed civil complaints seeking monetary damages and injunctive relief to prevent Bankman-Fried from being near a corporation or a company ever again. Now, the fines could be enormous in this case, but it'll probably take a long time to resolve, with potentially years of discovery and a string of bankruptcies to sort things through. The criminal case filed by the Department of Justice will go much faster. Now, Bankman-Fried was indicted for a number of different federal felonies, some of which meld into each other, but some are separate counts. And unlike the CFTC and the SEC complaints, if the DOJ convicts, Sam Bankman-Fried could be looking at a long sentence. The amount of time he gets depends on two things: the offenses of conviction and the federal sentencing guidelines. The sentencing guidelines provide 43 levels of offense seriousness. The more serious the crime, the higher the offense level. And each type of crime is assigned a base offense level, which is the starting point for determining the seriousness of the particular offense. Now, Bankman-Fried is not a prior offender, which would normally reduce the sentence, but the nature of his crimes is serious, and there are at least three different groups of victims here: lenders, customers, and the United States government. Now, wire fraud carries a maximum prison sentence of up to 20 years, and if the wire fraud involves over $550 million, which is possible if not likely here, then Bankman-Fried could get a maximum sentence, even without a prior criminal history. Securities fraud carries a maximum sentence of up to 25 years in prison and a fine that is based on the amount of money that was fraudulently obtained, which here was a lot. And a conviction for money laundering could result in a sentence of up to 20 years and a big fine. So if we look at it conservatively, assuming the government proves some but not all of the charges, Bankman-Fried could get a sentence of 10 to 15 years. There's still a lot of things that we don't know since the case is still in its very early stages, and it could be a lot more than that. Now, maybe the strangest story related to SBF's arrest is that his family reportedly called the prison to request vegan meals. Now, that's not going to happen, but he could get a delicious vegan meal from today's sponsor, Factor, or a keto meal, or a high protein meal, or a calorie smart meal, because Factor makes meeting your nutrition goals easier than ever by delivering fresh, never frozen, dietitian approved meals right to your doorstep, unless you're Sam Bankman-Fried. And the meals are completely ready to eat. Their team of gourmet chefs creates each meal using only ingredients with integrity to help you feel your best all day long. Factor supports wholesome eating made simple. Their menus are updated weekly and includes over 27 meals and 33 add-ons. You can choose your favorite meals or let Factor craft your order based on your taste preferences and meal history. Factor takes the guesswork out of grocery shopping and meal prep, saving you time and energy for other things. Factor's no-hassle prepared foods make sure that you always have something nutritious on hand when you don't have time time to think about making a meal. And sometimes I just want a delicious, healthy meal without having to cook. And Factor's meals arrive prepackaged and ready to eat in just 2 minutes. Meal plans range from 4 to 18 meals per week, so I can always scale up my meals if I need the extra energy for a long day of lawyering. And Factor's now owned by HelloFresh, so there's a wider array of meal plans to choose from. There's something for everyone, whether you want to cook it yourself or have a meal ready to go. So give Factor a try by going to go.factor75.com/LegalEagle60 and use the code LegalEagle60 to get 60% off your first Factor boxes. Or just click on the link that's on screen right now or down in the description and use the code LegalEagle60 to get 60% off across 6 boxes. After that, click on this box over here for more Legal Eagle, or I'll see you in court.